namely Government Senior Parent Council, UOI, private and corporate, both in-house and outsourced councils, appeared before the different courts of India, both as arguing and briefing counsel, well experienced in cross-examination of the accused, a passionate professional for the best legal remedy suitable to the client. Now, I would like to request Advocate K.R. Jha to come forward and present his lecture.
नमस्ते, मेरी आवाज़ जा रही है आप लोगों तक?
Yes, sir.
नमस्ते। बड़ा अच्छा मौका है और आप लोगों ने हमें बुलाया है, विषय बड़ा सुंदर चुना है। मैं अपनी बात को आगे बढ़ाने से पहले श्रीमान दिलीप सर जी और खुल्लर मैम से, यामिनी खुल्लर मैम से एक प्रश्न रखना चाहूँगा। हमारे लिए क्या उचित होगा कि मैं हिंदी में बोलूँ, अंग्रेजी में बोलूँ या मिक्स करके बोलूँ, और बच्चों से ही पूछना चाहूँगा कि आपको क्या ज़्यादा आसानी से समझ में आएगा?
मिक्स रखें सर, मिक्स
रखें सर।
60% it will be in English and then 40% Hindi.
So nice, sir. Thank you, sir. Sir, before I come to the topic, because the main issue relates to the Constitution and the body of the Constitution, which has been the highest body in this Indian democratic system, judiciary. Sometimes there is a saying that the whole country is being run by judiciary. So here the word judicial activism becomes the most important. The question is, we are in a democratic country where there are three organizations. All the three organizations have their own separation of jurisdiction and their own importance in the whole polity. Then why this judicial activism has become so important nowadays? Why this word has become such a big word? Everybody is debating about this. Why Supreme Court, High Courts are basically intervening into all kinds of issues. To understand this, I will go in the background of the matter. We will start with the Constitution. The Constitution of India starts with the Preamble. So let's first understand the Preamble. There is one sentence, Preamble is there. Preamble is said to be the entire gist of the Constitution. If you, it's basically give us the I was just trying to point out this, where is this preamble. Basically it's say what is the Constitution as such. Now let me read out the preamble. Preamble is, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Why did I read this Constitution? This preamble. I have read this preamble to understand what exactly Constitution wants this India to be? Where does this constitution will lead us in process? Each and every word of this preamble has its own philosophy. If we understand each and every word, what we have to understand that yes, each and every citizen is the maker of the India. You young chap are the future of the India. If we understand the preamble, we will understand the constitution as such. And if we understand the constitution as such, then we will understand that this judicial activism or non-activism, this executive, this legislature is none but all of us. There cannot be a conflict. There should not be a conflict. Everyone has to serve the nation for its betterment. Institutions are there, and so conflict should not be there. Now, let me come to the point that where do we stand when it comes to the law? This is the constitution. What is the status of all these facets in the constitution? To understand this, we will have to understand the law as such. Law, what is the ground law of the India? The ground law of the India is the biggest law is constitution. Second law is a statute act. Third is policy matters. And fourth is administrative actions. First is constitution. Now, in case of conflict, the first will prevail over all. My point is, suppose there are four kinds of law, correct? One is constitutional law, other is statutory law, third is some policy matters, and fourth is some administrative actions. And there is a conflict. Which will prevail? The first will prevail over the second, second will prevail over the third, and third will prevail over the fourth. Who will interpret it? For that, the law is to be made by legislature, and the legislature makes the law within the parameters of the constitution. So, if it comes to point out, to question the legality, the constitutionality of any provision is for the judiciary to see, adjudicate. Judiciary is there to interpret it. Legislature is there to legislate. Executive is there to execute. That being so, there is exclusive domain to all the three. But situations arises when judiciary, besides being the adversarial system, besides adjudicating in accordance with the adversarial system, it has to go beyond that. I will straightway come to my own experience to this judicial activism. Just a few days back, I was in the Delhi High Court. There, the issue was that few of the children who were suffering from the rare disease approached the High Court by way of writ petition saying that, praying for, firstly, that they are very poor, they cannot afford the medicine required for the rare diseases. And secondly, it's a life matter and it's the duty of the state to take care of his ailments and provide the medicines. So the petition was filed one person who was suffering against the state seeking writ that they should be provided adequate medicine treatment for their ailments. As lawyer of Union of India, I entered appearance. Other lawyers were also there. The first question which court asked was, do the Union of India have any policy on the issue? How to deal with the rare disease? This rare disease matter has been, for 3-4 years before the courts have been asking to frame some policy and etc. and produce it. My answer was, yes, we have policy. Being the Union of India lawyer, it's our prerogative, it was in our domain to formulate policy taking the holistic view prevailing in the country, qua the elements, treatment available, medicines possible. Usually, since we are the union, it's for us, it's our prerogative to, develop the policy. It is exclusively in our domain. But that policy itself was questioned by the court. Or ultimately, during the course of the hearing, an expert committee was constituted, and that committee suggested what actions are need to be taken for this rare disease patients. And the court finally gave a direction to us that you please modify your policy by this 31st March and place it before the court on the next date of hearing. Why this example is relevant here? Why I have quoted this example? This is called judicial activism. Thou, the policy as such was to be made by the Union of India. Still, despite of the fact that there was a policy, government was working on that, it has acted upon the policy several times. After seeking the expert opinion, the court found, yes, policy needs revision, some modification, and now we are under the process of modifying this policy. This is what the practical example of judicial activism is. This judicial activism wouldn't be there. As a government agency, would have been following the same, and the improvement which was required might not have been possible. So judicial activism as such sometimes is very important and help us to move further towards improvement. Here, if we go back to the preamble, it is so there we will find we the people of India, we the people of Bharat. It means that there may be 3 organs, there may be separation of powers, but when it comes to strengthening India, we all have to act together. Usually, judiciary should have not come forward, taking the conservative approach and view that it is none of my business. Why should I interfere? the policy matters are in exclusive domain of the Union of India or the state agency, they won't have interfered. And had that been shown, we won't have improved. So this is how judicial activism is required as long as there is no direct conflict. I'll come to the other example. There also I have an occasion to be the party as a counsel. I believe that you people knowing about this unorganized sector people, those who are vendors and etc., they earn their daily wages by vending on the street side, and they are allowed to earn their livelihood only at the discretion of the police and local authorities at one point of time, as there was no policy and there was no act. The matter was before the Honorable Supreme Court. For one of the NGO who works for the women in unorganized sector, I was the counsel. It was a long matter. Ultimately, with the intervention of the Honorable Supreme Court, each and every vendors were identified. They were issued I-card, policy was framed, and subsequently act was met by the central government. So this is how here also the Supreme Court, with its judicial activism, corrected the things in right manner. The other example, I believe that people might be aware that at one point of time in Delhi, it was very difficult to travel in the day. It was so polluted city. MC Mehta case is there. In MC Mehta case, the Supreme Court not only directed to constitute subsequently NGT and all, which is now a statutory body and playing a vital role in controlling the pollution. They ensure that all the polluting industries are thrown out of the territorial jurisdiction of Delhi. These are the examples through which we can understand how judicial activism has played a positive role in making the country, in growth of the country. So moto action. So moto word is quite known to you people. What is so moto? So moto is the more glaring example of this judicial activism. In last three examples, I said you that ultimately 1, 2 or 3 parties were before the Supreme Court or the High Court for redressal of their grievance. But in so moto cases, no party comes. It comes to the notice of the Supreme Court or the High Court, both being the constitutional body and constitutional court and having jurisdiction. And then they pass appropriate directions, orders, etc. How this courts function in so moto matters? They say that yes, I am taking notice of this matter, issue notice to the concerned authorities, administrative bodies, appoint their own lawyer, amicus curiae, to address on behalf of the respective parties, and after due course with full arguments, citations, taking views of all the parties, they finally come to the conclusion and pass appropriate orders and directions. Recently, in the pandemic time, so many issues came before the Supreme Court and High Courts. One of the matter was relating to the advocates, that due to pandemic, advocates are suffering, and some kind of redressal mechanism may be developed for them too. Our matter is going on. So here, so moto cognizance was taken of the issue. It is called judicial activism. Why this judicial activism has become important here? Because the judges are supposed to play a vital role when it comes to remedy the constitutional rights, fundamental rights of any of the citizens. PIL, public interest litigation. I believe that you people are getting the differentiation. Earlier I said petitioners came. Second time I said that suo motu cognizance notice is taken of the issues. Now I am saying the third thing. What is public interest litigation? There is a difference. In public interest litigation, any person who has no personal interest in the matter, but he feels for the public at a large, issue needs consideration by the Constitutional Court, they approach High Courts or Supreme Courts to pass appropriate direction. Every time we find that there is a difficulty, and I can go for the grievance if you people are suffering. 3-4 days back, somebody was approaching me. They are basically in Parents Association body of Delhi. Their grievance was कि in the pandemic time also, despite of the statutory provision and other directions, schools managements are trying to increase the fees, also trying to collect some development charge. Also, they are not publishing the result of the students for those who have not been able to pay their fees and etc. And the students are suffering. It was a fit case of PIL, public interest litigation. We are preparing the matter now. Earlier, in other matters, some directions have been issued that are being violated, we have come to know. So this is also comes within the domain of the judicial activism. But having said so, one more thing, constitutional rights. What is the constitutional rights? When the legislature, who is the most competent body, who have got all the constitutional power to legislate, whether it's a state or the central government or the Union of India, Parliament, they are the most competent body. They represent the entire people of their respective state, all the India as a whole, because they are the elected body. And they have got in the constitution duty to legislate. They do legislate sometimes in such a manner that those legislation do not stand the test of the constitutionality. Whenever Parliament or the state legislature legislate any act which is not in accordance with the provisions of the Constitution, that is questioned before the judiciary. Knowing fully that the legislation is the power and jurisdiction of the legislature, they do adjudicate upon the constitutionality of those acts. Judicial review. It is also a kind of judicial activism. Now the Supreme Courts and the High Courts at time again have been saying that we fully understand that it's for the legislature to legislate, so we should not be readily declaring any act or statutory provision unconstitutional. Yet there have been instances when the Supreme Court and High Courts have scrapped the statute or the statutory provisions. It is also the judicial activism. The question is, what are the parameters the Supreme Court or the High Courts usually takes into consideration while playing the role of judicial activist? See, the Article 32 is one of the articles of Chapter 3 which deals with the fundamental right. Fundamental right falls within the jurisdiction of the basic structure of the Constitution. And it is well established that no legislature or administrator, executives, can abridge, infringe upon the fundamental rights of any of the, as guaranteed under the Chapter 3 of the Constitution. So the Supreme Court judge the constitutional rights, take the suo motu cognizance, expand the adjudication, scope of the adjudication based upon the mostly fundamental rights, and other cases definitely on other legal technicalities issues are there. In constitutional matter, other statutory provisions sometimes also come into play. But for our understanding, as far as judicial activism is concerned, let's understand this way, that yes, it's basically the fundamental rights which are taken into consideration while playing the role of that of a judicial activist. Similarly, 32, as I said, everybody knows this, that is one of the fundamental rights of, as guaranteed under the Constitution. 226, Article 226, is also a protector of fundamental rights by way of different writs, but available in the High Courts, various High Courts. So the 32 and 226 are taken shelter of as a judicial activist by the judiciary whenever there is infringement of fundamental rights as guaranteed under the Constitution. The question is, if that is so simple, why there is so much of the whisper about this judicial activism? Let's understand this. That judicial activism some way, somehow can be seen as an effort by the courts concerned to overstep their own jurisdiction. At one point of time, they say they are not the expert, whether it's economic, financial, or other matter is concerned. But at the other side, they sometimes take the view without getting deeper into the matter. If we understand the framework of functioning of the court, in the first example, I was before a single judge bench. So single judge was deciding the entire issue. And a process of making of the policy in any policy, when the process is developed and policy is developed, so many persons are consulted. Minister is there. Committees are formed. And then a policy is developed based upon the financial provisions, data available, and etc. And that policy is questioned by a bench who is singly headed by a single judge. So there it appears sometimes that yes, judges are not able to comprehend the things as they should. I'm not saying that in this case they have committed it wrong, but at the same time I say that there is a possibility of conflict. That is why even the Supreme Courts have cautioned time and again that judicial activism should not be used as a tool to run the government, run the administration, make the new legislation. I would like to take name of Justice Karju. And Justice Karju, though he came into controversy subsequently, but while he was sitting in the Supreme Court with so many bench, he was very adamant, very clear that judiciary should not step into the shoes of any other organs of this country, polity. He was of the strong view that role of the judiciary is to confine itself to the adjudication only, not beyond that. You cannot fill up the gap. I believe that people may be aware that mutual divorce, there is a provision of gestation of 6 months between the two motions. Usually, exercising the inherent power, the courts have been granting mutual divorce, invoking this breakdown theory of marriage, saying that there is no point in leaving them to fight again. We can condone this 6 months period process. Exercising their inherent power used to pass these kinds of orders. Justice Karju objected it in a very strong manner. And he said that this way you are trying to legislate in your own manner, that you cannot do. And this view definitely give exclusive domain to all the three organs of our country, which is the requirement of this constitution. In fact, I was trying to point out one more. Justice Karju has illustrated that why judicial activism is not good as such. He differentiates it in two ways, positive and negative activism. He said that only and only if fundamental rights are glaringly infringed upon, then only recourse to this can be taken. There are other jurists, those who have time and again reminded that if two options are available when you are trying to judge the constitutional vice of any act, recourse should be that act is upheld or not that act is scrapped. So, from the first example till now, what I point out that judicial activism is required when it is for the benefit of the nation and the citizen as a whole. But if any way infringes upon the domain of the other body, legislature or executive, the judiciary is required to restrain itself. Before I part with this, I may point out to you that Article 142 reference may be required here to understand. Otherwise also, the Supreme Court has been given inherent power to pass appropriate directions, keeping in view the entirety of the matter. So, technically, if you ask that where does the Supreme Court get all these powers? The constitutional provisions are there to support Supreme Courts to pass appropriate order in the given facts and circumstances of the case. Sushant Singh case have been a quite controversial case at one point of time. You people will recall that it was quite controversial just because the CBI started investigation at Patna, Bihar, when the whole crime was committed in Mumbai. And Mumbai incident, the offense was also transferred to the CBI, which was investigating into the offense in the FIR which was allegedly committed at Patna. Here the Supreme Court, showing its judicial activism, exercising its power under Article 142, transfer Bombay incidents investigation, which usually could not be transferred to any other state agency because all offences are investigated by the local police, as we all are aware. Still, it was transferred to the Patna CBI, and investigation is going on. Matter is still pending. Result will come subsequently. Recently, Honorable High Court, recently Supreme Court, in one of the matters, it was a divorce matter. Maintenance was the issue. How much maintenance is to be given was the issue before the Supreme Court, because husband was protesting the initial amount which he was supposed to pay as per the first court order. High Court also did not hear him, so he came to the Supreme Court. Supreme Court was basically adjudicating issues between husband and wife. Instead of looking into this, why they are fighting, what amount should be awarded, they started investigating into the matter that what is the problem, why this maintenance issue is such a puzzling issue, why courts in India are passing different orders in different matter, why there is not a standard yardstick. Here we all know that every state has got its own local laws, because local customs practices are important when it comes to the civil disputes, mostly this matrimonial kind of disputes. But the Supreme Court.
Sir, may I interrupt you with due respect? Students want to ask many questions. Even they are very much curious regarding all your deliberation. So, if you give us permission, can we take one or two questions from the student side as well?
Sir, if at all you permit me, I'll finish it within 2 to 3 minutes more.
Okay, not an issue.
Maximum 2 to 3 minutes, sir. Please, sir.
Okay, sir.
Okay, sir.
Okay.
So the Supreme Court, what I was trying to point out, the Supreme Court expanded the scope of the inquiry, and it is called judicial activism, and issued standard guidelines needs to be followed while awarding maintenance in matrimonial disputes. Because Dilip sir has said me that you people have some questions, so please come. If at all questions permits me, I'll give you more examples. My idea was to somehow illustrate you through examples. I believe that you people have got it. Sir, please ask your children to.
Okay, Yamni ma'am, please moderate the QA session.
Yes, sir. Thank you, sir. Students, those who are having any queries or any questions regarding the topic or whatever sir have just given us the speech, please just let us know. Raise your hands and we can give you the chance for the same. Okay, Jyoti, you have a question, and Mani, please start. Jyoti, you can start first.
Yes, ma'am. Good afternoon, sir.
Good afternoon.
My question is judicial activism good for democracy or not?
See, it depends. Sometimes it is good, sometimes there is a conflict. NGSC, you may be recalling that day before yesterday, Chief Justice of India was trying to point out that yes, there are names which are pending for appointment as a judge in the high courts, and why this government is sitting over that. And the issue involved in that is that while rejecting that statute, the Supreme Court has itself said that MOP, Memorandum of Procedure, needs to be formulated that is still pending, and I believe there is a conflict, some kind of conflict is there. So sometimes it's good, sometimes there is a conflict, and when there is a conflict, I believe that any conflict is not good for democracy, so then that is not good.
Okay, thank you, sir.
Welcome.
Good afternoon, sir, and everyone.
Good afternoon.
Sir, I'm Mani. I would like to ask a question for the same. Do you think judicial activism plays a key role in keeping a check on the powers of the parliament?
See, the judicial activism and judicial review are two different things. A review is the inherent power with the courts, whether it's High Court or both the constitutional courts, High Court and Supreme Court. But activism is a role which has been basically asserted by the judiciary. So as far as judicial review is concerned, that is the duty of the courts. As far as activism is concerned, they do come with the activist approach when they feel that for the betterment, or the better interest of the citizens or their interest, they need to do more than to review the matter. So as far as review is concerned, it's okay. Activism needs to be used very diligently, and it's a delicate matter.
Thank you so much, sir.
Welcome.
Jha sir, the wow moment for this lecture is we have 10 odd students from the other university as well, like Delhi University, Ambedkar University, IGNOU University, and even some of the students from JNU as well.
Great.
So, some of the students want to ask a question whether the judicially activism will be helpful for the journalistic people or budding journalists. If yes, then how?
Journalists are playing the key role. The Constitution has recognized three organs, and journalists are the fourth one. So your activism does work. Whenever you report something, I believe मुजफ्फरपुर इंसिडेंट, इस बालगृह में जो कांड चल रहा था, वो का सारा श्रेय जो है आप जर्नलिस्टों के रिपोर्ट पे जाता है। आप लोगों ने जो रिपोर्ट की, उस रिपोर्ट का सो मोटो कॉग्निजेंस लिया गया, आपने फॉलोअप्स किया, उसका सो मोटो कॉग्निजेंस लिया गया, और अल्टीमेटली आप देखो जो वहाँ के कल्प्रिट्स थे उनको बुक कर दिया गया, और अभी चीज़ें बड़ी ही व्यवस्थित हो चुकी हैं। तो एज ए जर्नलिस्ट जुडिशियल एक्टिविज्म का तो आप सही पूछें तो ब्रेडन में सही पूछे तो आप ही उसको फ्यूल करते हैं बहुत बार। सो आप लोग ज़रूर से एक चीज़ जर्नलिस्ट लोगों को कहना चाहूँगा, बडिंग जर्नलिस्ट को थोड़ा सा विषय से अलग कुछ बताना चाहूँगा, अगर दिलीप सर अगर आप परमिट करें तो, क्योंकि आपके बच्चों को हेल्प कर सकता है। हाँ, बच्चों को हेल्प कर सकता है। तो मैं सिर्फ ये कहना चाहूँगा, देयर आर लॉज विच यू नीड टू एडहेयर टू। आप बहुत बार जो हम लोगों को समझने का मिलता है, हमने ऐसे जर्नलिस्ट को देखा है, वो परेशान होते हुए उन लोगों को देखा है, जो स्टैंडर्ड प्रैक्टिस है जर्नलिस्ट के कोर्ट के रिपोर्टिंग के प्रैक्टिस का, प्रोसीजर का, उसका ध्यान रखना चाहिए होता है। बहुत बार कुछ ऐसे तस्वीरें डाल दी जाती है, ऐसे नाम को डिस्क्लोज कर दिया जाता है, कुछ ऐसा ये लोग कंटेम्पचुअस अपना जो है सो बहुत बार ये लोग रिपोर्टिंग में व्यूज डाल देते हैं, और बाद में इन लोगों मैंने ऐसे जर्नलिस्ट को परेशान होते हुए देखा है। क्योंकि तो वो थोड़ा सा आप लोग जब आए तो अपने कानून में जो आपके जो क्या बोले पैरामीटर्स हैं जिस रिपोर्टिंग का, उस पैरामीटर्स का थोड़ा सा आप लोग ध्यान रखें। तो आपकी ज़रूरत तो है, आपके बगैर तो भारतवर्ष या डेमोक्रेसी नहीं चलेगा, और आपके होने से ही डेमोक्रेसी स्वस्थ है, मैं इतना बता सकता हूँ। जुडिशियरी भी अपना काम बहुत बढ़िया से निभा पा रही है। मैं आपको कह सकता हूं कि जजेस भी चाहते हैं बहुत बार, जब कोई अच्छी रिपोर्टिंग, अच्छे जजमेंट्स आते हैं, कि उसकी रिपोर्टिंग हो, उसका वाइड सर्कुलेशन हो, जिससे कि जो लॉ डिफाइन हुआ है उस लॉ की जानकारी अन्य लोगों तक पहुंच सके।
थैंक यू सर। मैं एक छोटा सा स्टोरी बताता हूँ। नीरज कुछ पूछना चाहते हैं, उसके पहले मैं बताऊं कि एक बार जो है वकीलों के बारे में लाइटर नोट पे बच्चे काफी देर से सुन रहे हैं, तो वकीलों के बारे में किसी एक बैलगाड़ी को एक सवारी बैलगाड़ी की जा रही थी और बैलगाड़ी को चलाने वाला व्यक्ति उस बैलगाड़ी पे सो रहा था, और एक वकील साहब ने देखा और देख करके कहा कि भाई तुम तो सो रहे हो, तुम्हें कैसे पता ये तुम्हें सीधे लेके जाएंगे या ये चल रहे हैं? तो उन्होंने कहा कि वो इसलिए क्योंकि इनके गले में घंटी बंधी हुई है, अरे बजती रहती है तो मुझे पता चलता है कि ये चल रहे हैं। तो वकील साहब ने कहा कि अगर ये एक ही जगह पे खड़े होकर के अगर अपने गर्दन को हिलाते रहे तो तुम्हें कैसे पता चलेगा कि चल रहे हैं? उन्होंने कहा कि साहब ये बैल है, वकील नहीं। नीरज आप एक क्वेश्चन और पूछ लीजिए, छोटी सी और एक स्टोरी मेरे पास है वकील लोगों के बारे में, जो कि वकीलों और जर्नलिस्टों का बड़ा पुराना रिश्ता है। हमें केस की ब्रीफिंग और केस के बारे में जानकारी अगर चाहिए होता है, इंडस्ट्री में हमने लंबे समय तक काम किया है, हमें पता है कि वकील लोग हमारी किस तरह से हेल्प करते हैं। तो नीरज आप पूछ लीजिए क्वेश्चन पहले, फिर मैं बात करूंगा। नीरज।
Okay, sir. Good afternoon, sir. Sir, I have question, sir. Why we name judicial activism, and what are the pros and cons of judicial activism?
अच्छा, मुझे लगता है कि आप ये समझना चाह रहे हैं कि why this word as such has been coined, correct?
Yes, sir.
See, the word last to last question was on the judicial review. Then I said that judicial review is the domain, is the jurisdiction, is the authority of the courts. That is why the court is there. The main duty of the court is the judicial review. But the judicial review was not enough. बाद में ऐसा लगा कि ये जुडिशियल रिव्यू काफी नहीं है, ये एडवर्सरियल सिस्टम से आगे भी कुछ सोचने और समझने की आवश्यकता है। तो अगर मैं थोड़ा सा इसको बैकग्राउंड में जाके बताऊं, तो जस्टिस भगवती के टाइम में पीआईएल के कॉन्सेप्ट को सही ढंग से इवॉल्व किया गया और सेव किया गया, और वर्ल्ड वाइड इस बात का कोई क्लेम किया गया, इसकी प्रशंसा की गई कि भाई जस्टिस पीएन भगवती ने यहां तक कह दिया कि एक व्यक्ति अगर एक पोस्ट कार्ड के ऊपर कुछ लिख करके अपने फंडामेंटल राइट्स के वायलेशन की चर्चा कि आपकी जानकारी अगर हाई कोर्ट या सुप्रीम कोर्ट को देता है, तो देयर इज नो रॉन्ग इन टेकिंग कॉग्निजेंस ऑफ दैट। तो जिस बैकग्राउंड सम है, भारत जहां पे था, 80 की बात है, 80 के दशक की, उस वक्त आप समझ सकते हैं कि ये अपने आप में एक साधारण नागरिक को कितना बड़ा आपने लाभ दिया, कितना बड़ा बेनिफिट दिया। अभी जो हम प्रधानमंत्री के अनेक योजनाओं की बात करते हैं, ठीक उसी ढंग से वो जुडिशियल एक्टिविज्म का सही पूछिए तो उन दिनों आगाज हुआ। अब वो आगाज के बाद हम आज कितने सारे कानून परिवर्तन, नई चीजें जुडिशियल एक्टिविज्म के ही कारण प्राप्त कर पाए हैं। वी द पीपल, मैं प्रायः इसलिए मैंने जो प्रियम्बल पढ़ा वो इसलिए पढ़ा कि वी द पीपल, अल्टीमेटली आपने व्यवस्था को चलाने के लिए 3 ऑर्गन्स बना दिए हैं, लेकिन जो सारा का सारा व्यक्ति है, चाहे वो हाईएस्ट ऑफिसर ऑफ दिस जुडिशियरी हो, चाहे आपका लेजिस्लेचर हो, चाहे एग्जीक्यूटिव हो, सब वी द पीपल का हिस्सा है। अगर सब मिलकर के साथ चलेंगे तो निश्चित रूप से देश जिस गति से आगे बढ़ रहा है उससे और आगे गति से बढ़ना शुरू करे। कॉन्फ्लिक्ट जब तक नहीं है तब तक जुडिशियल एक्टिविज्म का मैं समर्थक हूं।
थैंक यू झा सर। नीरज, कुल आपने जो सवाल पूछा काफी हद तक आपको समझ में आया होगा, क्योंकि ये वर्षों की तपस्या होती है जुडिशियल एक्टिविज्म को समझने के लिए। जब आप लोग जब उस फील्ड में जाएंगे तो आपको ज्यादा समझ में आएगा। एक छोटी सी स्टोरी है, देन आई विल हैंड ओवर टू यू फॉर ऑफिशियल वोट ऑफ थैंक्स टू यामिनी मैम। वो ये है नीरज की आपने क्वेश्चन ऐसे पूछा कि वकालत किसे कहते हैं, लॉयरशिप किसे कहते हैं, वकालत करना किसे कहते हैं। एक छोटी सी स्टोरी है और वो ये है कि एक बार उसने कहा कि मैं तुम्हें बताता हूँ एक उदाहरण से। जब सर ने सारे एग्जाम्पल जुडिशियल एक्टिविज्म के आप लोग एग्जाम्पल के साथ बताया बड़ा बेहतरीन ढंग से, तो वो कहा कि भाई दो लड़के हैं, एक बहुत गंदा है और एक बहुत साफ है, बताओ नहाने की जरूरत किसको है। तो स्वाभाविक है कि लड़के ने खड़ा होकर के बताया कि सर जो गंदा है उसको नहाने की जरूरत है। उसने कहा नहीं, गंदे को नहाने, वो तो नहाना उसको पसंद ही नहीं, उसको नहाने की जरूरत नहीं है। जो साफ है उसको साफ रहने के लिए कंटिन्यू नहाने की जरूरत है। उसने कहा कि सर बिल्कुल आप ठीक कह रहे हैं। फिर दोबारा वकील साहब ने पूछा, अब बताओ नहाने, अब दोबारा बताओ नहाने की जरूरत किसको है। तो उसने कहा जो लड़का साफ सर नहाने की जरूरत उसको है। कह रहा कि नहीं, गलत, नहाने की जरूरत क्योंकि वो पहले से साफ है तो उसको नहाने की जरूरत क्यों हो। जो गंदा है उसको साफ रखने के लिए अपने आप को नहाने की उसको जरूरत होगी। ये बता करके बच्चों ने कहा बिल्कुल सर सही कह रहे हैं आप। तो उन्होंने कहा कि अब बताओ सब लोग अब सब समझ गए हो नहाने की जरूरत किसको। तो उसने कहा सर नहाने की जरूरत जो गंदा बच्चा है उसको। कह रहे कि नहीं, बिल्कुल गलत, क्योंकि नहाने की जरूरत उसको क्यों होगी, क्योंकि वो तो ऑलरेडी नहाना नहीं चाहता है, तो उसको नहाने की जरूरत कैसे होनी चाहिए। तो उसने कहा कि अब बताओ नहाने की जरूरत किसको होनी चाहिए। तो कह रहे कि सर नहाने की जरूरत दोनों को होनी चाहिए। तो कह रहे ये भी गलत, अब जो साफ है वो साफ तो पहले से, उसको नहाने की जरूरत क्यों है, और जो गंदा है वो नहाना पसंद ही नहीं करता तो उसको नहाने की जरूरत क्यों है। तो एक तीसरे बालक ने खड़ा होकर काफी देर से जो ऑब्जर्व कर रहा था पूछा, सर कंफ्यूज हो रहे हैं, आप कह रहे हैं कि कभी ये नहाने की जरूरत है, कभी उसे नहाने की जरूरत है, और जब जब आप जो सब जवाब दे रहे हो सब कन्विंसिंगली बड़ा सही लग रहा है, तो हमें लगता है कि आप बिल्कुल सही बोल रहे हैं, हम समझ नहीं पा रहे सर नहाने की जरूरत किसको है। तो कह रहे इसी को वकालत कहते हैं कि जो अपनी बातों को वैलिड तरीके से कहे, प्रूफ के साथ कहे और सारा कन्विंसिंगली लगे। वही जरूरत है आप लोगों को भी कि जब भी आप मीडिया में रिपोर्ट करने जाए इतने वैलिड और इतने सॉलिड प्रूफ हो कि आप उसको इफेक्टिव ढंग से सोसाइटी में रख सकें और सोसाइटी में वो सब चीजें टेबल उसी रूप में करें। आज तक की जितनी लिटरेचर लिखी गई आप लोग देखें, चाहे वो गलत ढर्रे पे ही लिखी गई हो, लेकिन इतने इफेक्टिवली उसको प्रेजेंट किया गया कि हम और आप सब लोग उसको सही मानते हैं। बीइंग ए जर्नलिस्टिक स्टूडेंट आप लोगों की ये जरूरत है कि आप लोग सही सच्चाई को डिग आउट करें। यही थोड़ा सा हट करके जो लॉ से या लॉ को समझने वाले स्टूडेंट से आपको आगे ले जाएगा कि इसके ऊपर रिसर्च करें, रियल जो फैक्ट्स है उसको डिग आउट करें और फिर उसको आगे लेकर के जाएं सोसाइटी में। जैसे जहां सर ने कहा वो बड़ा ही बेहतरीन स्कोप है। और कन्फ्लिक्ट की सर बात कर रहे थे, कन्फ्लिक्ट जहां पर होगा डेमोक्रेसी के लिए वहां पर जुडिशरी एक्टिविज्म की जरूरत शायद वहां ना पड़े। मुझे लगता है कि हम मीडिया के लोग हैं, जब कन्फ्लिक्ट होती है तो आज जो मीडिया की स्थिति है, बाजार की मीडिया जिसे हम कहते हैं, बाजार की जरूरत के हिसाब से मीडिया काम कर रही है। मुझे लगता है कि थोड़ा सा हट के मैं बोलता हूँ, बाजार के हिसाब से काम करे विद सोशल रिस्पॉन्सिबिलिटी ठीक है, वहां जुडिशरी एक्टिविज्म चल जाएगा, लेकिन मीडिया बाजारू हो जाए ये ठीक नहीं है। बाजारू मीडिया नहीं होना चाहिए। मुझे पूरा उम्मीद है कि देश के आप लोग भावी जर्नलिस्ट हैं, मीडिया कर्मी हैं, क्रिएटिव लोग हैं और आप लोग अपने भविष्य में इस लेक्चर के साथ बड़े लाभान्वित भी होंगे और कामयाबी भी आप लोग को उसी रूप में हासिल होगी। होली की पूर्व आप लोग को ढेरों शुभकामनाएं। सेफ ढंग से होली मनाइए, सुरक्षित रहिए। जहां सर आपने समय निकाला बहुत बहुत धन्यवाद। थैंक्स टू ऑल द अदर कॉलेजेस स्टूडेंट जिन्होंने ये समय निकाल करके इस पूरे सेशन को एक्टिवली सुना। Even thanks to those people who are technically active in this particular session. Now over to you, Yamni ma'am, for official vote of thanks.
Thank you so much to Advocate K.R. Shankar ji, also our Professor Dr. Dilip Kumar ji. Listening to you was a treat to the ears. It was an insightful and informative session. Thank you for giving us your valuable time.
Thank you.
Now, I would like to request Dr. Yamini Kullar, Assistant Professor, Department of Journalism and Mass Communication, to kindly present the vote of thanks.
Thank you, students, for forwarding this dice to me. First of all, sir, I would like to extend a token of thanks and a gratitude to Jha sir, to you also, and Dilip sir, to you also. क्योंकि दिलीप सर ने हमें ये प्लेटफॉर्म दिया जिसके थ्रू हम आप तक पहुंचे, इनफैक्ट आपसे मिलाया भी, और सर आपको जिन्होंने इतना इनसाइटफुल इंफॉर्मेशन बच्चों को दिया और हमें भी साथ में इंफॉर्मेशन मिला काफी। Very thankful to the guardian of this institute, Shri I.P. Agarwal, the president of Mary Groups, and Professor Lalit Agarwal, also the whole department, faculty members, all the students, the organizing team, and to Google also, जिसने हमें इस ऑनलाइन प्लेटफॉर्म को दिया है अभी, क्योंकि अभी तो यही चल रहा है। सर बहुत ही आपने इंफॉर्मेटिव सेशन दिया, बहुत कुछ जानने को और समझने को मिला, और बहुत ही सरल ढंग से आई थिंक स्टूडेंट्स को ये समझ में आया है। So I think that they can understand all these topics and they can also इसको अपनी लाइफ में समझने की कोशिश भी करेंगे कि वो जर्नलिज्म क्यों करना चाहते हैं, क्योंकि आई थिंक जर्नलिज्म इज नॉट ऑल अबाउट द ग्लैमर। एंड थैंक यू दिलीप सर, आपने काफी हेल्प भी किया और मोटिवेट भी किया इस चीज के लिए।
थैंक यू मैम। बिफोर कंक्लूडिंग द एंटायर सेशन, जस्ट आई वांट कि जो बच्चे इंटरेस्टेड हों, सर ने इतने सारे केस का जिक्र किया, उस केस स्टडी करके आप लोग एक प्रोजेक्ट बनाए, दैट विल इवन ग्रेट फॉर यू पीपल, और आप लोगों को उसकी इंसाइटफुल जो नॉलेज होंगे वो भी जानकारियां होंगी आप लोगों को। तो आई होप कि यामिनी मैम उसको कोऑर्डिनेट कर लेंगे, और बच्चे जो इंटरेस्टेड है, वी आर नॉट गोइंग टू फोर्स एनीबडी कि आप लोग करना ही है, लेकिन जो इंटरेस्टेड अगर वो उनको करते हैं तो डेफिनेटली आई विल गिव दोज गाइज टू सच अ प्लेटफॉर्म जहां पर उनको अपने टैलेंट को और ज्यादा शोकेस करने का मौका मिल सकता है। इनफैक्ट अगर वो केस इतना अच्छा रहा तो मैं जहां सर के अंडर में उनको इंटर्नशिप करने का एक मौका भी दे सकता हूँ। ये रिक्वेस्ट तो मैं इस प्लेटफॉर्म पे कर ही सकता हूँ।
बिल्कुल सर, स्वागत है आपका।
जी थैंक यू सर।
थैंक यू सर। नमस्ते सबको, नमस्कार।
हाँ जी सर,
नमस्ते।
थैंक यू सर। और सब
वेलकम।
जय हिंद, जय भारत, ओम शांति।
और होली की बहुत बहुत शुभकामनाएं मेरी ओर से भी। आप सबको बच्चों जम के खेलें होली, कोविड का ध्यान रख के सर।
Thank you,
ठीक
sir.
है, ठीक है, तो नमस्ते।